Now, businesses are usually full of realists, and often circumstances are fluid. One day, what was a good contract, what was a good deal 2 days ago may be less than ideal now once circumstances have changed. Accordingly, it is possible that parties to a contract can terminate an agreement by agreement. They can enter into another agreement to end or to terminate a contract that no longer suits their business purposes. There are two different avenues in which parties can terminate an agreement by agreement. The first one is it's wholly within the party's ability to enter into an agreement, the very first agreement, that contains its own termination clauses. So you will know at the outset when you enter into a contract that it's going to terminate upon the happening of a certain event. You just know. You can deal with it, and you have the foresight to be able to deal with it in advance. However, there are circumstances where parties enter into a contract that doesn't have that type of clause, where the parties are after the fact looking to figure out what sort of agreement they can enter into that will have the effect of terminating their original contract and usually setting up a new one as circumstances have changed and they want a different deal. Let's look at these examples. So the first example is what's called an option to terminate. It's always within the party's ability to enter into a contract that contains a contractual term that allows one party, at its option, to terminate contract. Usually this is subject to conditions. Maybe they're limited in their ability to, when they have to exercise this option to terminate, maybe they have to give specific notice. Consider an example of employment. It is always within the option of a employer and an employee to terminate the employment contract with a specific period of notice. You may find as well that options to terminate contain specific details regarding consideration. Maybe the option to terminate comes with a payment of some sort of money in lieu of debt. There are three different types of conditions that the parties can place into their agreement that will have the effect of automatically either terminating a contract or creating one without requiring the election of any party. The first example is what's called a condition subsequent. What happens here is that the contract is in existence and it's operating until the happening of a given event. Once that event happens, it will automatically terminate. The second example is what's called a true condition precedent. And in this case, the parties don't actually have an agreement until the existence or the happening of an event. There's no contract until the event happens. This is prudent in a situation where maybe you're not quite sure if the contract itself is going to be legal and you're in the process of figuring it out. Then there is no contract up until the happening of an event, i.e., you get the go-ahead for regulatory approval of whatever contract you're making. It can get a little bit confusing because there's also a type of condition called a conditions precedent, which sounds a lot like a true condition precedent, but it's a little different. Condition precedents are quite common in, say, for instance, the real estate industry. And what a condition precedent does is the contract exists. The parties enter into a contract for the sale of land. But let's say that we put in a condition precedent of subdivision. Now, the parties have a contract for the sale of land. What the condition of getting subdivision does is it exists to relieve the parties of subsequent obligations if they are unable to get subdivision. So unlike a true condition precedent, the contract exists before and possibly after. The secondary obligations still exist. It's just the primary obligations don't have to be performed because the condition has not been satisfied. Now let's look at situations where the parties want to terminate a contract after the fact. So they've already signed on the contract. Party A has agreed to give X. Party B has agreed to give Y. And now they've realized, maybe this isn't such a good deal after all. This is not what we want. What options do they have? The first option is rescission. The parties can agree to rescind the contract and treat it as if it never existed. However, the availability of rescission is limited to circumstances in which neither party has performed. So basically, the contract is what's called executory. It's not executed, it's executory. They have not done anything other than signed on the dotted line, and it's really easy to put the parties back in their place. It's really easy just to rip up the contract. So that's rescission. The second avenue is what's called accord and satisfaction. This is a circumstance where maybe you don't want that shed anymore. Maybe you want a swimming pool. Maybe you changed your mind. Where the parties agree to change out the consideration that they want. And so rather than party A agreeing to give X and party Y agreeing to give, party A agreeing to give X, party B agreeing to give Y, maybe party A agrees to give Q and party B agrees to give R. That's a lot of letters. Basically, though, if either party changes their consideration, then both parties are giving something new and you have a valid change of the contract. It's called accord and satisfaction. The last one that I want to talk about is something called novation. Novation is a circumstance in which the parties replace one contract with another. Simple as that. The textbook goes into detail regarding whether you can have a two-party novation or a three-party novation. Really, for the purposes of this class, I just want to know that it is possible to have as consideration, rather than performance of a contract, replace that contract with a new one. And this happens when the parties want to change their bargain and enter into a different contract because the original agreement is not what they wanted. Of course, we should always remember that there are circumstances in which parties can terminate a contract without any consideration at all. In those circumstances, like a promise given under seal, we've talked about these before, no consideration is required. Another circumstance in which no consideration is required is what's called waiver. And waiver looks a lot like promissory estoppel. You'll recall that equity has created this doctrine of promissory estoppel. But in this case, we're talking about the common law idea of waiver. And waiver requires a gratuitous promise. I promise not to enforce my end of this, or not to enforce my rights under this contract. The other party relies on that promise. And similar to our discussion of promissory estoppel, it is possible that I can still retract my gratuitous promise, provided that I give reasonable notice to the other side.